Welcome everybody to the third episode of the Oral History of Data Protection Law. This is a collaboration between the EDPS, the European Data Protection Supervisor, and LSTS, the Law, Science, Technology and Society Research Group of the Free University of Brussels, VUB, here in Brussels. My name is Gloria González Fuster. I'm the director of LSTS, and I'm really very happy to be here today with two exceptional guests. The first one, the person that we will interview, has been described to me by somebody who knows a lot of data protection commissioners are their favorite ever data protection commissioner. So I'm very happy that I can finally meet somebody's favorite ever data protection commissioner. This is Waltraut Kotschy. Welcome to this episode. Welcome to the EDPS studio. And we will ask you questions. I will ask you questions together with Laura Drechsler, who is assistant professor at KU Leuven. You're also a researcher at the Belgian Federal Archives. And you are Austrian, and I think you share many, many things with our special guest. So I hope you will help me also do the best interview possible. And before we even do this, you can introduce briefly our special guest for the audience.
Yes, thank you, Gloria. It's my pleasure. So our guest today is Waltraut Kotschy. She studied law and economics at the University of Vienna, and she also obtained a doctorate in law, and worked then at the university as also an assistant professor. And then she moved via the Constitutional Services of Austria to the Austrian Data Protection Commission, where she really was there from the very early days, so from 1980 onwards, and was responsible also for international European representation of the Commission. So was also involved in the Article 29 Working Party and all these initiatives. She then was also still at the Chancellery of Austria, and there played a very important role, as far as I could find out, in the making of the Austrian Data Protection Law of 2000. And then after, you went and became Commissioner of the Council of Europe for Data Protection.
That's right, yeah.
So another important milestone. And then since 2010, I could see you were doing a lot of consulting and also still at universities, a lot of trainings. You seem to know about every topic that there is. So I'm looking forward to asking you questions.
Thank you very much and welcome. And as you know, and as the audience knows, we like to learn about the history of data protection law. And one of the main questions is, how did our data protection experts become data protection experts?
Good question. Good question. Yes, actually, this is mainly due to the fact that when I joined the Constitutional Service of the Chancellery, they sent me to a computer school for 1.5 years, so just aside, naturally. So I was one of the very few people at that time, that was 73, 74, who had any idea, a practical idea about data protection. So I learned to do little drawings and all that. So when but at that time, data protection wasn't the topic yet. That was earlier. And I have a little bit of difficult sort of life because my husband was in the foreign service. So I always had to leave the country for several years and come back and see how the situation was. And when I came back from Brazil, I remember correctly, I was asked whether I would be interested to start the new service for the Data Protection Commission, because we had from 1st of January 1980 onwards the first data protection law. And this law naturally required some sort of organizational structure. And this was this first Data Protection Commission. And we had in Austria a long tradition with such extraordinary organizations in the civil service. They were mainly, so normally it was 4 or 5 or 6 members, and 4 or 5 were coming from the civil services themselves, and one had to be a judge. He was always in charge of the whole thing. And where the civil servants were acting for the commission, they were independent. But in their normal profession, they were just civil servants. And there wasn't much organization behind, as a little bit, but nevertheless, it was a job. And I was very interested because it's something completely new. And that's when I started out with this Data Protection Commission. And then I had to leave the country again in 84. I went to Sweden. And then we went to Yugoslavia, the then Yugoslavia. And when I came back, it must have been beginning of 93. There was by chance, there was the job in the constitutional service, which I had been in. It was free again. So I started again in the job in the civil, also in the constitutional service, leading these, how would you call that? The department, or whatever you would call it, the department which was in charge of data protection, but a lot of other things too. And at the side, that was our Austrian solution, I was still heading this Data Protection Commission, because in the time when I started, it was only the Data Protection Commission. But in the meantime, when I had been out in one of the, they had joined the two things. As it wasn't my doing. It just happened in the meantime. And they thought it was possible to do that. And that's how it went on until 2004, when I said we can't do that any longer, because I saw how the other services were dealing with the problem of a data protection supervisory authority. And I really felt you can't have this combination any longer. That isn't the style which is done in Europe. We had some troubles doing that, but in the end it came out with two separate services, so to speak. One stayed in the Chancellery, the normal civil service, and the commission was then concerning the people who worked for the commission. They were only working for the commission. What still was not 100% was the organizational structure. And for instance, we couldn't choose our personnel alone. I always had to ask somebody whether they would agree, and which wasn't always so satisfying, let's say that.
I think you explained everything we wanted to ask you already, but I would like to go back
let's
a bit
go back.
slower, because when you were studying law, what I understand is that actually that period was quite interesting at the University of Vienna.
Well, at the study time, I wouldn't say that. Okay. That was, so I was finishing my studies in, let me see, 68. Okay. There was no EU law and no data protection, not even far. So I must say, on the university, I didn't learn much of what I needed afterwards, only constitutional law, because that was my main profession. So for my age group, it was quite difficult to get EU law, because we never had any real training. It was all training on the job.
Yes, but about the advent of computers, this is what I've read, something that there were already some research projects which were about computerization. Were you involved in this kind of events?
That's true, but I wasn't involved. Actually, I left my job as assistant professor in order to become involved. Okay. Because it was the Federal Chancellery which had the idea they wanted to do something in this field. And they started out with a project where they wanted to make the judiciary of the Constitutional Court searchable by new means. And for that project, I changed my job and went into the Chancellery. And there I went to the computer school, and there I had my first, how shall I say, contact with this new world. And maybe that's funny to report. We did something which was, in the end, quite interesting. The way how they treated this project was quite primitive still. There were several people knowing something about constitutional law, and they read these judgments and they put some catchwords. Also, it is really very primitive. It's not something terrific which takes out the catchword, but we had to put in a catchword. And then the only computerized thing was that you could search in these files. Okay, and there came up the problem that the German grammar is quite complicated. So you have different cases and all that. And if you put in a word and it isn't exactly that word, you won't find anything. So I thought we have to do something. And I went round to the university again, to the linguistic departments, and tried to find somebody who was interesting to do something together with me and find a way to combine all the different cases. If you catch, so if you put in one word, you would catch all the documents where the same word comes up in another form. And this we did together with IBM. IBM was the technical part of the whole project. And we made, for German, we made this system together with IBM that you do not have to think about anymore about the forms of verbs. As today, it's quite self-understanding. But at that time, it wasn't, because that was really little problem.
No, that indeed sounds like you solved one of the big mysteries at the beginning of IT and data. Going back also maybe to the beginning of the Data Protection Commission. So you said you were there from the very, very first moments. How was that like to just start a commission on data protection? What was kind of the first tasks you were tackling?
So it was, for me, it was even a little bit difficult insofar as I came back from abroad. I had not been involved with the development of the law. So it was really all completely new, but it was also completely new for the others. Also, we have this federal system in Austria. It's also perhaps quite interesting to remark on that. We had good luck, I would say, because somehow it was avoided to have this federal system with 9 data protection commissions plus 1. We have only one. We always had only one, and we still have only one, which makes everything a lot easier. And we are a small state, so I mean, it's also less costly. And in this respect, there were only people for whom data protection was a new topic. So we all tried to understand this new law. And what's also perhaps quite interesting, this first law, it was completely, the background was completely the European Convention on Human Rights. So all the exceptions were formulated in the same way as we were used according to the ECR. And in that respect, we had actually 2 laws in one for the public sector and one for the private sector, because people felt or were very unsure whether it was really possible to pack all that in the same system. And at that time, we had the Data Protection Commission only for the public sector. Also, the private sector was organized in a way that you could only go to court, to normal civil courts, and the Data Protection Commission was only reserved to the public sector, which is quite also today, well, it came up again with the choice finally between the 2 systems. But in the meantime, we had a different system, but we are coming to that later.
So you were not personally involved in this 1978 law?
No, unfortunately not. I was not there.
Yes.
Yeah.
But I suppose, well, you were somehow involved with or in contact with the people who were in drafting?
Rather not, because I was in Brazil.
Okay, it's far away. It's far away.
Yes.
But I was wondering, because you said it took as a reference the European Convention of Human Rights. Can you tell us something about what was the international influence? Because we know that many countries really looked at Sweden, at other countries.
Yeah.
Did you have this kind of
Well,
influence?
I'm sure. I can't say for myself because I haven't been there, but I'm sure that they looked into everything which was existent at that time and what was under discussion at that time. And the Austrians evidently felt on the safe side if they had the Human Rights Convention as a background. Also concerning the problem of, let's say, the way how you get your data protection rights, how shall I say, set through and that. So the whole system was actually really oriented on the Human Rights Convention. And that is quite different, actually, from what we had from 94 on, no? When we acceded to the EU.
And very quickly, so when you started with the Commission, you became involved in Council of Europe discussions representing Austria.
That is a slightly other question. This constitutional service of the in Austria always was very much involved with the Council of Europe. And I remember I was at a conference in Budapest. And there were a lot of Eastern countries. And it must have been, I'm sorry, I haven't made any notes, but it must have been something like 95 or something like that. And they were discussing, and I thought these poor countries, they never have a chance to get something like a bridge to be able, let's see, to be something like adequate to the EU way of doing things. And I thought something has got to be done. Because at that time, we didn't know that in 2004 everybody would exceed it. That was, at that time, was quite out of the question. We thought actually it would take a long, long time until they would succeed. So this idea to find a way how we could make or achieve something which would make it easier for a lot of European countries to become something like adequate to the EU standards. This developed in this thing there in Hungary, and a little bit later on, it must have been in '96. I didn't have time to look it up. The Data Protection Commissioner of the Council of Europe was a Portuguese, the chef of the Portuguese Data Protection Commission, and he asked me whether I would be interested to succeed him, because that was always a two-time job, usually. And I said yes, because probably I could do something within the Council of Europe, which would make it easier for people to exceed. And that was the beginning of the additional protocol.
Okay. And was this, were you involved in this idea of having this additional protocol?
Yes, I was the chair. I was trying to draft it and trying to push it, and
because it brought together two of your favorite subjects, I will say, independent data protection authorities and cross-border data flows.
Right. Also when I started making this job of them, it was more or less combined also with the chair in the working group in the Council of Europe. And there I found other people who were interested in probably doing something. And we tried to get this additional protocol drafted and all that. And the first step was naturally to pinpoint where are the big differences between the Convention 108 in its 10 features and the standard of the EU data protection norms. And we found that, I hope it's true, it was first of all these data protection supervisory authorities, which are not mentioned in the Human Rights Convention, naturally, and this transporter data flow. That was the beginning of the thing.
Yeah, of course, that's a topic that I personally find also very interesting. So can you elaborate a bit more? So you were involved in this additional protocol. I guess were you also then involved in the Article 29 Working Party discussions? Because I remember they had some early
yeah.
documents on transfers and authorities.
Yeah, yeah. Also, we had our public vote on accession to the EU in 94. And I remember from middle of 94 onwards, we were already allowed to sit in the group which was discussing the new data protection norm. And we didn't have a voice yet because we weren't member, but still we were allowed to sit there, listen, and probably also bring something in. For instance, we brought in the idea that defending your rights and interests in front of foreign courts or whatever is always a legitimate interest. As in all that comes from our experience with transported data flow, because we had a very strict system of controlling all international data flow. So we had a list of all the possible cases, more or less, which come up if you want to make some rules on international data flow. And we found that that was missing in the list of the EU directive. So yes, as we were sitting there and already listening heavily, and well, forgive me, and I've forgotten where I wanted to. What did I want to answer?
Article 29 Working Party.
Yeah. Also, from the beginning of 95 onwards, when the first things were developing, so not in 95, a little bit later, we were always members. So I was there in the 29 Working Party from the beginning, but I was also there in the working group, naturally, of the member states from the beginning. So I had a very good oversight of what was going on.
I think this is related, I would say, to one of the major themes looking at your career, this,
Yeah.
I would say, a double personality or a double role that at some point had to be clarified. I don't know, you seem to say, well, you experienced this as a limitation, as a problem. Was it since the beginning that you experienced this is not fitting, or how?
No, I wouldn't. I would be careful. I would say in the beginning I was very grateful because I knew everything what was going on there. But when I saw, when this whole thing developed, I mean, there were countries which hadn't even transposed in 2000. So you see that that was a long development, and we needed until 2000 to transpose the directive. But then, so after 2000, things became a little bit more concrete. And we saw how the others had organized their data protection supervisory authorities, and that there was a great stress put on the question whether they were also organizationally, also not from your mindset, but organizationally divided. And therefore, I thought that we couldn't really keep up the system, which was very practical because you knew everything. We couldn't keep up that system any longer. And in 2004, I had finished a big project in the Chancery, which was the e-identity. We had a very early system of electronic identities. And when we had finished that with a law, then I thought it was time to do something. And it was not received so, how shall I say, people were not enthusiastic because they were used to the system and it was very practical and didn't cost very much because people were working for two sides. But in the end, we needed more personnel in the commission because there were already coming more and more complaints. And the commission was very small, there were 10 people or something like that in the beginning. And really didn't work out like that any longer. And then as we managed to divide the two things from 2004 onwards, nobody was working for the two organizations. Everybody was only working in one of those. We divided, so to speak.
And you went to the
I
Data
went to the
Protection
Data Protection
Commission.
Commission. Was my choice, yes.
And in a way, it does look a bit strange that the law, the 2000 law, did not foresee this development, or
Not really,
Okay.
not really, because this development in the other data protection authority that was really taking place after 2000.
And then for the audience also to understand what happened, I believe you actually submitted a complaint, or you launched, because
No.
eventually there was a judgment.
Yeah.
But
No.
what triggered this judgment?
Yes, I'm happy that you give him the opportunity, because I do not want that there is much misunderstanding. No, I would never do something against my own country, no. I was not involved at all at that, as far as I know, because it's only background knowledge. The commission was visiting the chancellery, and they had a long dispute, and it was evidently a heavy dispute. I was not involved. I was not there. And I think this procedure was the outcome of this heavy dispute.
Good. And then, so eventually the commission started looking at the Austrian case very
Well,
closely.
Maybe I can attribute still something, because it must be also a little bit funny. I think one of the triggers also was that in a certain constellation, somehow it came out that I was not allowed to come to an Article 29 session. And at that session, I even would have had to do the chair, because the real chair was not able to come, and we had such a, how shall I say, a swave appointment. If he can't come and the second can't come, then I jump in. And at this time, I was not allowed to come to Brussels, and naturally the Commission was aware of such an impossible situation. It was really impossible, because being able to come to the 29 group is one of the first obligations you have as a commissioner. As it was silly, I'd say, that this situation developed like that, and maybe I have been one of the triggers.
So you were not then.
I was not complaining. It
Not
just
complaining,
developed.
but in a way you understood the situation, so it made sense to you.
Yeah.
And then, do you remember how was the reaction when the judgment came, and then they kind of had to arrange themselves again?
Well, one more has to be said, perhaps, to understand the Austrian position. They had a lot of these independent commissions, as they called it, which were founded on the Human Rights Convention. Also, under the Human Rights Convention, it was tradition that these commissions, with a judge at the head of the commission, and then civil servants who were no, sorry, who were independent when they were voting in the commission, but they were not independent when they were doing their other jobs. So this system was considered to be okay under the Human Rights Convention, and that this system should not be okay under EU law was something which was difficult to accept for our lawyers. And therefore, there was so long a sort of discussion whether we should join this new way of doing things, because it has always been good enough under the old system. I think if you understand that, then you can better understand why it took a court procedure before the EU, a CJEU, which is actually from nowadays it's a little bit ridiculous. But since we always thought it was good enough under the convention, then people evidently thought it should be good enough under EU law also, which wasn't.
I think it's interesting how perhaps for some Austrian lawyers it was difficult to accept, but I suppose for you it was easier because you were really constantly in contact with international data protection authorities.
Exactly.
And you were very active also in this European and I think also international commission gatherings. Is that the case? Yes. Could you tell us more perhaps about these international activities?
Yeah, so well, I mean, if I may say so, the data protectioners are travelers.
Yes.
We were getting around. And so I tried to be involved in all of these. And I was also, at that time probably already, yes, quite heavily involved in activities in the Eastern countries. Also whenever somebody wanted to change the law and come nearer to the EU standards, there were always EU projects, and I was very willing to help them if I could. And so I think I have been in every capital in Europe outside Bucharest. Bucharest, I've never been.
For a special reason? No,
No,
it's
no,
a call for an invitation
just
for.
Chance, simply chance.
This was a way of also merging your skills. No, you had this diplomacy skills somehow, or this knowledge of.
Well, a tendency also. I mean, being near to foreign service, it always creates a tendency to be interested in other people's habits and customs and how they want to do it. So I was really traveling a lot and coming around and getting to know a lot of other systems, how they tried to do data protection in the very beginnings. But, for instance, in Poland, I have been quite a lot of time. The lady who was the first commissioner, she was very open, and she wanted to have a lot of contact and advice and whatever we could furnish to their system.
And is there something that you learned through these experiences, how to explain data protection to countries?
Yes, probably. Explaining is something which is very necessary, and also not being on the high horse, trying to understand how the others see the problem and what they can contribute to solve their problems.
Yeah, and then to go back again a bit to your role as a commissioner at the Council of Europe. So you said you did the additional protocol, or you worked very heavily on that. What were some of your other tasks? And also, I mean, the early 2000s must have been quite a period for data protection law, because things were picking up with the directive, and we had this additional protocol. So can you explain a bit more on how was it like to work in data protection in those years?
Naja, also it was really, how shall I say, full of projects. Also in the Council of Europe, for instance, these were the years when even the Russian Federation came in. Yes, they were members. It was very interesting to listen to their explaining of how they see the problem. It was a short period, I must confess. What we also, it was not only the work in the working group where we did this additional protocol, but we also had something quite interesting to do as a commissioner, because they had this problem, or brought it up, the people in the service. How can we have a look into what people are doing with these new products like internet, and they all have computers now, and they are sending out mails and all that. How can we achieve a sort of control over what's going on, or is it not allowed to have any control over what's going on? And here we developed a system of the English word is a bit difficult, a sort of incremental control, how you start. I mean, you have data protection, and it's quite accepted that people use to a certain extent their hardware also for a bit of private use. And how do you do that you can manage to know what's going on, but still not to be too heavy on data protection? As we developed such a system, and I must say, I introduced it then in the Austrian system too, because we had the same problem at home. And we introduced it into the law on the public service. We had some legal provisions then on what how shall I say, what could be done from the side of the civil service to see that the civil servants don't overdo things and don't write their most private things into from an address, which is actually the government address. No?
Coming back to this decade, year 2000, there is a little episode that we think we should, because we are at the EDPS, we have to ask you about this. So you did apply to potentially become the beginning of the EDPS. It didn't work.
No, it never worked out.
And I think there was an unpleasant episode connected to this. I don't know if you want to talk about this, where actually there was an attempt to discredit you.
Well, I would like to say something general. No, being in the working group of the countries, of the member states, naturally was also involved in the development of the regulation on the EDPS. But having more experience nowadays, what we did not really think much about in this working group was how the EDPS should be appointed. There was nothing in the regulation. From my point of view nowadays, I think that was a huge oversight, because it worked out that having such an important position without any real norms how to get to an appointment was completely counterproductive, because it was a weird sort of, I can't even say it was a procedure, it was nothing. It was just happenings, chance. Somebody said suddenly, I want to have the prerogative on nominating the substitute, and the other said, I have a prerogative on nominating the first one. But that was just out of nothing. It just developed like that. And in this environment, I think one of the problems was that when I applied, I think I only applied for the EDPS, and I didn't say that I also applied for the assistant. Yes, and then they made a question out of that. So it was all a mess. It was a real mess.
What was interesting is that actually in the Austrian judgment, the independence of the EDPS was taken as a standard. So in a way, it did have positive influence somehow in the development, nevertheless, I suppose.
Yeah. So every time it didn't work out, it was always second. Nevertheless, it didn't ruin my work.
Yes, and then just looking in general at your career, you spent a lot of time with public authorities, and then at some point it changed, and in 2010 you moved to.
I retired.
Retired.
I had to retire.
So we call this retirement because you have been so active that it doesn't look like a retirement.
Well, I had to retire. I even worked a year longer than it was allowed. But they wanted that we finished the 5-year appointment of the commission. And that's why I worked 1.5 years longer than normally. But when I was 66 and a half, I had to retire. There was no choice.
So this retirement is quite busy, isn't it?
Yes, indeed. Indeed.
Because we were both impressed. You are still giving trainings, not just on data protection, but on everything else that has happened in the Data Governance Act, the AI Act.
Yeah, what is so near to data protection can't be avoided to also think about that. So therefore, I decided we must have that also in the training, because people can't only be so one-sided, no?
And would you have expected that, like being there from almost the beginning of data protection law, that it would be so important one day and will be leading to so much other legislations?
Probably not, actually. Also, when I think about the 95, 6, 7, it was just a little bit something exotic. And we were all doing many things besides. That it really became such an important topic, I didn't foresee in the 90s. But later on, I mean, it really started out to be something, and something which really you had to take care specifically and not do many things aside. As long as I was in the federal chancellery, I always had to do many things aside. For instance, in 2000, we made, I never know the English word for that, Rechtsbereinigung. We made, I don't know what's the English word. If you clean up your normative structure. Also, you throw away all the...
Yeah.
We throw away all the old norms which you don't use anymore, and you look through it. As of that we did in 2000, for instance, had nothing to do with data protection. And then the next big project was this e-identity for the Austrian civil, also for the Austrian whole structure, for also for problems of health. Also even for the health sector, we introduced this electronic identity, but contrary, let's say, to the Swedish way, for instance, it's an identity which is privacy friendly, which is hidden.
Yes, and there is a question that we have not really discussed, but in many of these contexts, I suppose you were one of the few female participants. Was this the case? Have you experienced this? Was this a problem, or have you experienced? Do you think it was a problem potentially somehow? What was your experience of this?
So I wouldn't say it was a problem, but it was. It was. Also, for instance, in this constitutional service of the Austrian government, I was the first woman. And but later on, I had the feeling that data protection is a female job.
In Austria, apparently quite.
Yeah, because in the 29 group, there were a lot of ladies. Many ladies.
Eventually, maybe, yes, still a minority, I would say, for many years.
Beginning, but then more and more. So I remember when they're sitting there, the Dutch had always a lady. I mean, true, it wasn't the boss. It was the lady who was taking care of the international affairs. Those were a lot of ladies.
Yeah, and then maybe also if you would now start with data protection, would you do it differently? Would you go maybe also this direction, both having an IT background and a law background?
Yeah.
What would you advise someone who wants to start with data protection today?
It's a good question. And I think today it would really be advisable to have also a technical background, because it's becoming so difficult and so important to understand the technical basis in order to make a good judgment on the legal side. I think it would really be necessary. And that makes it extremely difficult, because who has such a background? Because it's easy to have a background of law and economics. That's not so difficult. But I mean, law and a real good technical background, that's rare.
We are approaching the end of the interview. Unless, Laura, you have a specific question. I think it's really interesting to see all these developments, and perhaps you're saying you didn't have this technical expertise, but you were sent to study computers. So maybe that made a difference for you at some point.
Yes.
That was an added value, that you had an understanding, a way of thinking about the technical reality. Would you say that was important?
I won't overdo my technical knowledge, but at that time it was unique, because the other people didn't know anything about computers and how it works. And I even could program and so on. So it was already something at that time. And in the meantime, I mean, we'd all do our best to keep up and ask other people. I must say, we had a very good cooperation until 2004 and even longer with the Technical University of Graz. I cherished that. And whenever I didn't understand anything, I asked these people, and they had to stay as long as I needed to understand it. And that helped a lot because that were the real experts. And therefore, it was for us not so hazy because we insisted on their patience until we really understood it. And maybe you need such a helping, and maybe such a cooperation could help. Because if it's not possible for one person to be trained in both things to a high percentage, at least you would have somebody who is used to explaining it to juridical persons, which is not easy.
I think this is the challenges of interdisciplinarity. This is
Yes.
still a very important challenge. Good. Just a little final question. If you have to think about what could be the contribution of Austria to data protection thinking in general, I know in practice there's another Austrian person, Max Rems, who has been actively contributing.
We know him very well.
But from a conceptual perspective, perhaps, is there something that you think, retrospect, this is really what we brought, or something that was specific to us? Is there something that you will identify?
Yeah, that's a bit difficult. I mean, we have problems, for instance, at the moment with this dual way of getting your rights done, with this choice way. Although I must confess, in the very beginning, we had a rather similar system, no? Private. But I must say, you never had a choice in Austria. You had either courts when you were the private sector, or you had the data protection authority in the public sector. And then we switched the system in 2000, where the Data Protection Commission became competent for all questions of access. So access was done for the whole nation only before the Data Protection Authority. And we have now big problems to adjusting to the jurisprudence. Not so much in the private sector, because our Supreme Court, just having a long tradition of judging data protection things under the law of 1980, the Supreme Court decided they are competent because we have a law in Austria saying that for all civil matters, the civil courts are competent unless there is a law saying explicitly that the civil courts are not competent. And our transposition of the GDPR has a law, naturally, but they didn't say explicitly. They probably meant explicitly, but they didn't say so. So the court is quite right to say there is no explicit legal provision, so we are competent. So the private sector is no problem at all. But we do not know how we have this dual way in the public sector. I do not see how that should function, because there is no court where you could go to.
So this is about access to remedies, having the choice between the DPA and the court.
There is no way. I don't see how they will do it. I mean, we just don't talk about it at the moment.
Good. So I get the Austrian contribution is to just ask questions, have to deal with the problems.
Yeah, and whether it is really such a good idea to have so many possible ways of getting you right, because they may contradict quite a lot.
Good. So we will think about this. We thank you very much for your presence here. We conclude the third session of this oral history of data protection law, and we hope to see you for the fourth episode very soon. Thank you very much. Thank you very much.
Thank you. It was a pleasure.